No, thank you. An interesting lead in to some of the topic I'm going to be talking about now, because I'm going to have a look at jurisdictional issues and why they actually matter in cloud computing. I understand that there have been a number of questions over the series of recent Cloud Circle events where people have asked questions and come up with areas they'd like to look at, and some of the questions that have been asked have been sort of set out in the sessions today. So I'm going to start talking through what's there. But the first question on the list is, why does location matter? Why is it that sort of the lawyers and some of the technical architects start getting interested in where the data center is, where the data is, what type of data it is? And hopefully I'll talk through some of that analysis with you now. Of course, as we've seen from the previous session, we're really talking about outsourcing something to the cloud. But if you outsource something, you can't completely outsource or transfer accountability for that information, data, or whatever you're putting in there. The final risk is going to sit with the user. And therefore, some of the burden of compliance and some of the regulatory issues need to be assessed by the user before they put things into the cloud, because actually regulation might impact on them to a point where they might want to vary the provider that they're going to go with, and I'll give you some examples of where that can happen. They might want to look at a solution, or they may be interested, as Steve was talking about ring fencing their data in Europe, or keeping it on a server and making sure it doesn't go to a certain jurisdiction. So with the cloud, as we've seen, there's a potential to move a lot of information around very quickly. And also then that information can move to different jurisdictions. With jurisdictions and new territories come new issues. And to start with, at the beginning of this session, I'd like to talk a little bit about quite how data can get there and where the issues are, and then step back and look at one or two of the issues which may impact that data, and therefore may impact the risk profile of putting that data out there. A lot of what I'm going to talk about isn't specific to cloud computing. In fact, there's pretty much no law out there which is cloud computing specific. So we're applying existing laws, and we're also looking out there to look at laws in other jurisdictions. And of course, in a session like this, you're almost focusing in on the key risks and the key issues. So to some extent, it can become quite negative. I think the main message is, just because there are barriers and hurdles doesn't mean that you can't create yourself a working cloud computing solution. And what you've got to do is look at the underlying factors, the underlying architecture, what you're putting together, work out what laws impact, and then work out what your risk profile is in relation to that laws, in relation to those laws. With a cloud, there's somewhat of a fear of the unknown still. It's still not well understood. It's been fantastic to see Nathaniel sit back, talk through some of the earlier session about what's SaaS, what's IaaS, what's PaaS. Because people are starting to get a hold of that. Because you're removing servers from your own control, because you're removing data from your own control, people start to get nervous. Oh, it's with someone else. Lawyers are like, oh, do you trust them? What do you know? That's the sort of question you should be looking at yourself, because you're responsible if you're a user. But there are issues of trust. There are issues of understanding control measures that are put out, and then perceptions that because it's cloud, because it's new, it's a less developed legal system, and there are more questions out there, so there aren't the definitive answers which sometimes people look for. There's also this potential for exposure, because you're touching on multiple points, and that's the sort of thing that gets people nervous. That's the sort of thing that makes lots of lawyers write lots of negative articles about the cloud. That's the sort of thing which puts people sort of on notice that there could be risk. So let's have a look at cloud just to start with. I mean, cloud with a restricted geography. We've already heard about that from Steve. We'll ring fence it in the EU. Why does that matter? I mean, no different to having your own servers in the back of your office. You've got a ring fence system, data's not moving, using the cloud. You may then better use the cloud and use the benefits of the cloud to move data around. So if you're you might not store the data you're responsible for on your own computer, and if you start moving that data or information into other territories, you might have to start grappling with the law and the jurisdiction of other territories. If you do start moving your data, you need to start to think about the data, what's being processed, what's being accessed, and by whom. Because that's going to be too important. At some point, the law's going to start to cut in and say, actually, you don't do it like that, or you can't do it like that, or if you do it like this, you need to go through this other hurdle. And that's where you can start to become restrictive and cause yourself issues. But first of all, let's have a little look at just a couple of hypothetical examples about how data could move. Heard from Nathaniel earlier, different types of solution you could have out there. I mean, in my solution here, we've got Office apps via SaaS, could be CRM via Salesforce, could be Google Mail, stored on servers in the US. We've got IS data storage, using the data center in Pune. Lots of information being stored. It's cheap, it's relatively easy to maintain. You've got some Brazilian development taking place, hosted on a server out in Brazil. The potential to suddenly move across the world and enter into different jurisdictions. And therefore, all of a sudden with the cloud, you're leveraging lower cost countries, you're leveraging perhaps infrastructure which isn't being used because it's quiet in the middle of the night, so you can use spare processing capacity, or you're using a service which has been developed in the US because it was launched there. Most of the data centers are out in the US. Why is that a problem? Well, perhaps it's not. It'll certainly present one or two hurdles, but then we've got to start looking further into what that means. Let's just have a quick look at the complexity which you might get out of just having that IS service, that data hosting in Pune. Well, actually, it turns out that that data hosting is also subject to automatic replication. It's backed up to another data center somewhere else. Actually, that data center is run by a third party and supported by a third party over in Brazil. They've got the ability to pull down information from this data center, read it on screen in Brazil. At that point, you've got information which originated here, was probably captured here, moved into Pune, automatically backed up to here, so it's being stored in another country, and then can be accessed by someone somewhere else. By the time we cross this bridge here, that's potentially within your own control. If you've got private cloud and it's your own hosting center, you could have moved to a third party here, but at this point, they're using another third party to replicate the data center, and they're using another third party to support the database elsewhere. At that point, you've actually got to look at the matrix of there's risk there, and as lawyers, we start thinking, ooh, gives us problems. And why does it potentially give us problems? Because there's quite a lot of law out there which causes some issues. So what I want to touch on is just asking some of the questions that some of you have been asking about. Why does that location matter? Why are we keen on jurisdiction? It's not just a nicety that we like the idea of the fact the data centre is in the EU. There's actually a bit of EU law which is restricting us. So to start with, we've heard about due diligence from Nathaniel. We've got to start looking at what's out there and getting an idea of what's the supplier's doing, what you're using as a service, what kind of information is out there, what data is going into the cloud effectively. And if you know what data is going out into the cloud, you can start thinking, is it personal data? Is it confidential data? Is it something that I've promised someone else that I'll look after in a certain way? Is it trade secret? It could be something which we don't publish to the outside world because it's our secret recipe. It's the way we do something. It's the know-how in relation to our patent, which, although the patent's public, the know-how really gives us our competitive advantage. Is it third-party data? Have you obtained it from someone else? Are you doing something on behalf of somebody in relation to that? Is it your customers? Does it include pricing information, the sort of thing that would be sensitive to if it got out there? They're all kind of questions that you'd ask anyway if you were sharing with somebody else, even if you were using somebody down in a data center outside Swansea. They'd still be useful questions to ask in relation to a third party if you were transferring data. The fact it's the cloud, it's a little bit unknown. The fact it could then move elsewhere, and some people perceive that movement as potentially uncontrollable, starts to raise questions. And one of the questions which you hear about, and one of the acts I was asked to mention was the Sarbanes-Oxley Act of 2002. First piece of legislation which, if you're a US listed company, as you know, reaction to the Enron sagas and the rest back in the 2000s, the US Congress introduced legislation which said, okay, if you're a company, you need to have internal controls. You need to understand what your business is doing, both in the US and overseas. And if you've got that data and you've got information, you also need to be sure about what kind of provisions you've got in place in relation to email retention, in relation to data security, integrity and oversight. I mean, to some extent, the sort of things that Mimecast is helping you do in terms of mapping emails coming in, emails coming out, but you've got an obligation, and as a CFO at the end of the year, you've got to sign off and say, I've got those internal controls in place. Now, if you're outsourcing to the cloud, and we go back up to, if we can, sorry, hang on. Page up doesn't work. Let's see. Okay. So if we're in a cloud situation in Sarbanes-Oxley, information originates here, been stored in the EU, it's moved around. Now, at the point of reporting at the end of the year, you've got to consider that act, all the jurisdictional issues of that information moving around. So it's the first piece of legislation which you hear people banding around like, oh, Sarbanes-Oxley. more often than not, you hear it in the EU, oh, I can't do that because Sarbanes-Oxley. It doesn't even touch them because you're not a US company that's listed. It's the sort of misinformation you see out there. So you've got to get your facts straight. Is it actually a piece of law which applies to me? The problem with a session like this is I'm going to rein in hundreds of different pieces of legislation and issues. I'm not going to present just say all the easy parts. I want to try and highlight some of the risks. The point is, all these risks don't occur at the same time, so don't take away that this is a barrage of negative issues. They're issues for some, but let's sit back and work out whether it's an issue for you and do a little bit of interrogation to work out whether it's something that should be thought about. So, talked about that. Talked about this beginning of this due diligence. You've got some very interesting questions about what data is going into the cloud and what's happening to it. And for the first time in the UK, November last year, the Information Commissioner, who is in charge of introducing and implementing and enforcing the Data Protection Act in the UK, actually came out with a document called the Personal Information Online, a Code of Practice. And that was really an indicative code of practice, not law, but some kind of indication about the way ICO will look at the way information is processed. And for the first time, they actually gave a little bit of advice on cloud computing. Now, we were all quite excited about this promise of information on the cloud. Actually, they just gave us a bit of common sense that we knew already, but it's useful, and I'll just give you the example of what they've said. They said, your use of an internet-based service must not lead to you relinquishing control of the personal data that you have collected, or expose it to security risks that would have otherwise arisen had the data remained in your possession in the UK. There must be a written contract in place. This can be an electronic one, requiring the internet-based service provider or cloud provider to only act on your instructions and to have a level of security equivalent to your own. So I'll start going into the Data Protection Act, look at why that's relevant. But for the first time, really getting a reiteration, all right, ICO specifically in relation to personal data, and there are lots of other types of data out there, but they're saying you can't relinquish control. You've got to exercise the type of control you would have done had it been in the UK. So you've got to look at your business and say, well, if it was in the UK on my servers, what systems and protections would I put in place? Just because you pop it out to a third party, you need to be thinking about the same systems and the same types of control. Now, that could be an issue in two ways. First of all, you can actually be a small business sending out information to a much larger business. In that circumstance, you actually might be giving it better protection and better security controls than you ever had in the first place in the server in your back bedroom or back of the kitchen. So it could well be the cloud could be giving you more protection. In other instances, it could be giving you less, and you've just got to start making that judgment. But suddenly, we've got a simplistic analysis which the ICO is starting to talk about. Is who's responsible for it? Well, if you've collected it, it could be you, but if you're processing it on behalf of somebody else, it might ultimately be that third party's responsibility. They've just given it to you and you've got custody, and a contract could be talking about how you use that information, what can happen to it. So we've looked at our map, where could it move around, and what about getting it back? What's the technical proposition? And I think importantly for cloud, what if this changes? Just because you ask the questions today about, oh yeah, we've ring-fenced your data in the EU, is there anything which actually says tomorrow we can sign a low-cost way of doing it in Pune, so we'll move it all out there? And is there any restriction on what you're going to do? So these are the sort of things that if you start breaking down and making that kind of analysis, in time, you can use that analysis to do two things. Analyse the service that you're preparing and deploying, but then also use that information to inform the contract that ultimately you're putting together. And as we've seen from the Information Commissioner, you've got to have a written contract. Well, that's because it's personal information, and the Data Protection Act goes on to talk about a written contract. But why would you not have a written contract anyway? And why would you not protect yourself and put in certain provisions? Now, the problem, again, with cloud, quite a lot of these services are very much a commodity service. They're very much take it or leave it. Yes, you can have it. Yes, you can have the low cost. Yes, you can have the benefit of our low cost Pune operation or wherever it is. But it's really on these terms, and this is what you're going to do. If you're paying a low value, you probably don't have much negotiation. I work for a lot of cloud providers and I've got a lot of sympathy on the other side of the fence, because whilst sometimes a lawyer like me advising you, you've got to have this, you've got to have this, you've got to protect this. Well, you're paying £1,000 a month. What do you want me to do? So I've got 30,000 customers. I can't vary this system specially for you. So then that becomes, do you want to take the risk? Is it a risk that's acceptable? Or is it something which you can therefore pull back from and say, well, actually, it's not the way I want to do it. I want to keep it in my server.